Thank you all for letting me be here and be a part of this, and for all of the consideration. The questions today have been, I think, very thoughtful, and I appreciate it. I also want to really echo the thanks to the survivors that are here. And I also want to just note for the record that Steve Doreen is here, who I don't know if everyone in Wisconsin knows what a treasure you have in Steve Doreen from a victim's perspective, but he works nationally on behalf of survivors, and he's here. So I just wanted to acknowledge that because he's one of my mentors too. My name is Meg Garvin. Just by way of background, I'm a University of Minnesota law degree holder. Please don't hold that against me. Still like the Midwest, not in Minnesota anymore. I'm now out at Lewis and Clark Law School. I had to move out of the cold this weather today. Dear God. Oh, Senator. I know you get strength from it. Yes. I am now out in Portland, Oregon, so it rains a lot. I'm a law professor there at Lewis and Clark. I am also the executive director of the National Crime Victim Law Institute. Let me just take one moment to tell you what that is and what we do, because I think that's where I may be able to be of assistance if you have some questions. So the National Crime Victim Law Institute was founded in the year 2000. And we were founded really for the purpose that you're all talking about today. How do you improve criminal justice to ensure that it's beneficial to both the accused and the victim? And the idea is, how do you make rights for victims meaningful? So what we do nationally is we work with prosecutors' offices, victim advocates, victim witness coordinators, and victim attorneys to ensure that rights are meaningful in criminal justice processes. So we don't do civil law, generally speaking, sometimes some collateral moments, but mostly we work with victims and their lawyers and their advocates in the criminal case to take the laws on the books and see, are they meaningful in court? So I file motions on behalf of victims in criminal court. I co-counsel with lawyers around the country, taking laws akin to what you currently have, and more importantly, akin to what you are proposing to put in law with Marsy's law, which makes it clearly enforceable, meaning clear that a victim can do something with it in court. And I help that victim move that right forward if they want it. So I work all over the country. Last year, my institute worked in almost 30 states. The year before that, we worked in 42 states, looking at their laws, trying to ensure that when a victim wants to assert them, when they want to be notified, when they want to be present, does the law allow for that through motion practice if no one else is going to carry the water forward? So that's what we do. I want to just take just a couple of minutes to provide a little bit of national perspective and then be available to questions for you. And so the national perspective is based on some of the Q&A I've heard today that I just want to flag a few things. One, why constitutionalize, right? There's been a little bit of an undercurrent in that in the conversation today, and I know in 2017 when this was debated also. What we know from more than 30 years of experience with statutory victims' rights across the country is that statutes alone do not change the conversation. I thought one of the survivors who spoke, that was a brilliant articulation. And as a law professor, I may steal your words and use it for my students. But statutes do not change the conversation in the courtroom, particularly with judges, right? If you walk down the street right now, or if you even talk to a judge, the first rights they'll articulate are constitutional rights. Generally speaking, federal constitutional rights, right? And then below that, state constitutional rights, then statutes. That is actually the first thing we teach in law school is hierarchy of law. The higher it is on the ladder, the stronger the right is, and the more it compels conversation. So why constitutionalize? Because it compels a different conversation. The second reason of why constitutionalize is the same reason that the U.S. Constitution Bill of Rights was drafted as it was. And in fact, some of the drafters of the U.S. Bill of Rights had this same debate. If you go back and read the history of the U.S. Bill of Rights, the question was, why constitutionalize rights against government, individual rights against government? And the responses from the drafters of the U.S. Constitution Bill of Rights were, you put in your fundamental document those fundamental values that you want to hold forth in society. That's what goes in your Constitution, right? So when you constitutionalize victims' rights, you're saying this is a fundamental value of this community. We're putting it there. So Wisconsin, brilliant in 1993. You did it. You were a leader in it. It's been 26 years, and a lot has happened in that time period for us to start to understand, how do you constitutionalize victims' rights, right? And what we have learned is that with constitutional rights, because from the years 1900 to about 1975, the criminal justice system in the United States had moved to what is known as a victim exclusion model, right? We had moved from what was originally, at our founding, a victim-centered model. I'm a total geek about history, so I'd love to have a side conversation about that. But 1900 and 1975, we had moved to this victim exclusion model. And so the first iteration of victims' rights in this country, both statutory and the constitutional ones in the 80s and early 90s, were drafted in a way that were, well, let's put it in law, but have some language that makes it not as compelling as perhaps it needs to be, meaning not as enforceable, not as clearly enforceable. What we learned between the 80s and 90s all the way up until really the early 2000s, when laws started to be revisited, when constitutional amendments started to be revisited, was clarity in victims' provisions in the Constitution with regard to enforceability, standing, those pieces that say, if my right's not afforded, I can do something about it. That's what makes them meaningful. That's what we learned from multiple decades of trying to do something with rights for victims, is that if it's not clear, the enforceability of it, nothing happens. So that's why Constitutionalize. Second point I wanted to make about the national scope of this, or the national landscape of this, is to respond to a couple of the questions about South Dakota and Montana. They were slightly conflated in the conversation earlier. So a couple of things. One, there are numerous states in this country that have constitutional rights for victims that are enforceable, akin to what you're considering. Not all of them are labeled Marsy's Law. Marsy's Law is a relatively new framing of enforceable victims' rights that started to come into being in 2008 in California, right? Oregon modified its constitution in 2008 also to make them enforceable. It's not called Marsy's Law. They were just separate approaches to it. But across the country, numerous enforceable victims' rights exist in Constitution. They're each unique. So when you start to look at what's similar, what's different, what are we looking at with regard to South Dakota, Montana, North Dakota, Nevada, if you analyze them, they're all very different. The South Dakota provision that's most contested right now, and the one that was being spoken about earlier, the law enforcement officers, to the best of my knowledge and everything I have both read and reaching out to some victim advocates on the ground there, the provision they're citing is not a general privacy provision. It is the provision to prevent disclosure of records used to harass or locate the victim or to disclose confidential information regarding the victim. That provision, as my understanding, was in the first iteration of your Marsy's Law that was being proposed in 2017 based on both experience out of the Dakotas and from stakeholder input. You struck that so that you would not have that same problem. That's the provision that's at issue, particularly with regard to law enforcement officers claiming victim status in that engagement. The Montana provision is the provision that was struck down on procedural grounds. And Montana's provision was struck down as unconstitutional because of the mechanism by which it was put in. And Montana's provision is, or Montana's constitutional law is similar to only one other state to the best of my knowledge, and that's Oregon's, which is how you have to put things into a constitution. You have single subject and you have separate vote. It's a very technical thing. Leg Counsel probably knows it inside and out, is my guess. But it was a unique thing in Montana. That's it. Right? So they're very different. It wasn't struck down on substantive grounds. So as you consider and as you're really thoughtfully engaging in this, when you're comparing to other states, look carefully at their language to see what's similar and what's different. What I know about yours when I was rereading it, because I had read it in 2017, but when I was rereading it, I was astounded at how much of the language is clearly Wisconsin language. This is you. This was done from the best of my understanding. I remember seeing an early draft in 2017, and this is a compromised piece of legislation that you all worked on very carefully. And so it's you. It's built on your history. It's built on your case law. It's built on your statutes, and it's built on your stakeholder input. And the last thing I want to engage in is some of the conversation that was over here about the right to discovery or the right to refuse discovery. And I want to frame a couple of things very quickly. Law professors are never quick. I'm sorry for all the lawyers in the room know that. But as quick as I can. I know. So first, Is it facially unconstitutional to include a right to refuse discovery? It is not. I understand where that opposition comes from. I understand it because culturally we see the defendant's rights, particularly the right of confrontation, the right of compulsory process, and the right of due process. They're so present in our conversations. But if you actually go look at U.S. Supreme Court case law, U.S. Supreme Court case law is crystal clear on this. The right of confrontation is a trial right. It does not attach until trial, which means by denying a pretrial discovery moment, you are not even touching the right of confrontation. It has not arisen in the case yet, so it's not at issue. The right of compulsory process, similarly, is a trial right. It is a right to compel something to show up at trial. And I'll come back to that in 1 second. And the right of due process, courts are split on whether that is also a true pretrial and trial right with regard to production of information or not. The majority of jurisdictions in this country have said it's more akin to confrontation, which means it really attaches at trial. So what does all of that mean in layperson terms? It means that the right to refuse discovery, generally speaking, is not going to come into conflict with the defendant's U.S. federal constitutional rights. When it does, when a defendant can make a showing that he, she, or their interests in a fair trial, right, which is the general term for those rights, is going to be compromised by not getting a piece of information, he, she, or they, the defendant, will get it, including pretrial. And the 8 states that have had the right to refuse discovery in their constitutions for a number of years, pre the most recent Marsy's law, right? So as of 2017, there were at least 8 that had it in their constitutions. That's how they have ruled. When it is state constitution versus state constitution, to your question, this is not an unusual thing for a court to have to engage in, right? To say, we have 2 co-equal rights. What do we do with them, right? That's not that unusual. Courts routinely look at co-equal rights and say, in this moment, under these facts, which one takes priority right now? And the court then says, that one takes priority right now, and I will afford you the other right up until that moment. So if we take the U.S. constitutional examples on this, right? Defendants under the U.S. Constitution have a fair trial right, which is manifest in the right of compulsory process, due process, confrontation. The press has a U.S. constitutional right? Freedom of the press. Courts routinely in this country are looking at both those rights. They're co-equal and saying, in this moment, does the media get a camera in the courtroom? Oh, wait, we have co-equal rights. What do? Well, the court analyzes it and says, you know what? In this moment, if I allow a camera, defendant's fair trial is utterly eviscerated. So you know what? I'm not going to allow a camera, but I'll allow the camera when other witnesses are testifying, right? They figure out the puzzle pieces to say, how do I do my best to afford both rights to the greatest extent? And when one is going to actually eviscerate the other, then that one has to take second seat. Right? It's a judicial process that happens routinely in our country. Will it have to happen here? Yes. Will your courts have to figure some of this out? Yes. Right? But that's the price we pay for constitutionalizing rights. We say, as a legislative body and as a people, we say, we believe this is a fundamental value. We want it to be analyzed on a case-by-case basis. We want these human beings, both the defendant and the victim, to be treated as human beings. Now, court, please figure it out so that both of them get procedural justice in this process, and then we move forward. So with that, those were the only things I heard in I have a lot of notes because now I'm like, oh, this is interesting. But I want to open myself up to questions if anyone has any from my practice.
No, you don't get credit for hearing the talk. But if you could do that, that'd be good. We got credits. This is really good. Representative Spreitzer, go ahead.
Thank you, Mr. Chair. Thank you for addressing some of the questions I brought up. Just to follow up specifically on that right to refuse discovery. So, can you walk me through, kind of an example from what might be a typical situation of where there might be, not just a fishing expedition, but a request that somebody might think is legitimate, for discovery, but where a victim might assert their right to deny that, and kind of, how that would potentially play out, particularly if that victim's right is ultimately going to be honored without infringing on the defendant's rights.
Yes. So this is one of the areas that I would say in my practice in working with the survivors I work with, both either directly or through others, the privacy right and the right to refuse discovery are the moments that are most prevalent for a lot of survivors. I do a lot of sexual violence, domestic violence, child cases, and trafficking, as I heard you mention. And privacy, right, the question of do I have to give up everything to participate in justice or not, right? That's the question. So how does it play out? I will use a real case example and see if that's useful. And then if it's not, we can extrapolate. Does that work?
Sure.
A case we worked on in California, so I'll use a California example, post-state Marsy's law there. I'm not going to use real names. I'm happy to provide briefing on this afterwards, but I'm not going to use names on the record here. A minor victim of sexual violence received a subpoena directly. So not a third-party subpoena. Those are the ones that would go to like your doctor, your counselor, but a direct subpoena. And the survivor received a subpoena asking for her Facebook messages, not her posts, but her messages. I had to figure out what that was. I didn't know what it was. I thought they were the same thing. For those of you who are social media illiterate like me, that's the slightly more private. It's kind of akin to an email, Facebook email, yes. Received a subpoena for that and for her diary. And I believe there was something else in the mix, but the diary eclipsed my world because it freaked me out. I brought my own biases about diaries to the table. She wanted to assert her right to refuse discovery, to oppose that. And so it was basically, there was litigation. The prosecution was on board. There was an adult and a juvenile case happening. There were two perpetrators. And one was proceeding in adult, one was proceeding in juvenile. And thankfully, in that situation, they were both proceeding, thankfully from the survivor's perspective. And the judge looked at, A, is this a fishing expedition? B, what privacy rights are at stake, right? So her right to refuse was the motion in opposition to the subpoena. She asserted her right to refuse discovery. That's what it was. And then what the court had to do, and I'm so sorry, representatives, for having my back to you. What then happened is the court had to analyze who's right. She had the right to refuse, she asserted that, but then she also had some privacy rights, she had some confidentiality rights, right? She had never disclosed it to the prosecution, so there was no, for the lawyers in the room, Brady at issue. The court ended up saying that he had not, the defendant in the case where this actually was litigated, had not made a sufficient showing in the case. So hers prevailed in that moment. The court said, however, right, properly so, if the defendant, through the course of this case, uncovers additional information such that he can make a different showing that he can get this, then I'll reconsider the issue. And that's how it played out. We have also, in a real case on the flip side, in Oregon, there was a subpoena for a survivor's computer, and this is post the enforceability. So this is an Oregon case, so slightly different phrasing, but still has the right to refuse discovery. Post enforceability of rights. Subpoena for the victim's computer because she had reported a sexual assault, and they wanted to see her Google searches predominantly. Long story, but I can explain it to you at some point if anyone's interested. And she asserted her right to refuse. There was litigation, and the court in that one ultimately said, he's made a sufficient showing. He gets the computer. And she's still challenging it, but the computer has been preserved to ensure that he, the defendant, has a fair trial while they determine if, in fact, he should get the actual ghost of the computer, or mirror. I can't remember the actual technical term. I apologize. Yeah, exactly. Yeah, exactly. So the right to refuse is the right to say, as someone, I believe Leg Counsel had said, no, right? It's a plain dictionary definition of refuse. And then you figure out whose rights are at play in terms of once you assert the right to say no, does someone have a right to get it? Because historically, and I just want to put this on the record too, there is no U.S. constitutional right to discovery from non-parties pre-trial. There is no U.S. constitutional right to discovery from non-parties pretrial. It's, again, a trial right that exists, or you have to say some other right that exists. So it ends up happening in a relatively routine fashion that you figure it out. And going to the cost question, it's not a high litigation moment. It's a subpoena, motion to quash subpoena, and you're just including the arguments of why you would quash the subpoena.
So both of those examples were in states after they had passed something comparable to what we're looking at today, and the victim whose personal things were being asked for was asserting a right under their version of Marsy's law, basically.
Yes.
So in one of those same situations in Wisconsin today, before we've passed Marsy's law, but with our current statutory and constitutional rights, how would either of those play out here? What would the victim be able to assert or not assert?
So I believe the victim can still assert certain of the rights. I'm trying to get the language in front of me. You have in statute some of the rights, but what you don't have is clarity of enforceability of the rights, meaning, for instance, the Oregon case, we went up to the Oregon Supreme Court to protect that computer. You do not have clarity of appellate process under your current at all.
Thank you.
Questions, anybody else? Cody? I'm sorry, and then Alberta,
Thanks for being here today. Would you
and then Shay. Shay too.
would you speak to a possible analogy between rape shield laws and how that plays out at trial and the victim's rights here in order to not produce discoverable evidence ahead of trial, whereas the court then has to make that determination whether or not, in the interest of justice, it's warranted?
Representative, my geeky side is now very excited by this question because I haven't thought about it this way. I haven't framed it in quite that analysis before. But right, so rape shield is a rule of evidence for those in the room or on the record who don't know. And the rule of evidence, it is what information can actually be admitted into court, generally speaking about my prior sexual history or activities. And so it is a rule in which you say, I want to admit this, and someone says, well, that implicates my prior sexual history, and then you decide. And it is about what comes in at trial, but you assert the protection pre-trial. So in terms of the procedural aspects of it, it's similar in that you would be attempting to protect things from ever coming into being and moving into the public sphere in the first instance, rather than having to try to close the door afterwards. So I think that's akin if that's where you're going with the question, but I'm not sure.
So we already do this in our courts
I see.
currently.
Under rape shield.
Correct. Okay. Thank you.
Thank you very much, Mr. Chair, and thank you very much for your testimony. It was really informative. And
Thank you, Senator.
did you vote, did you register in favor or for information, or how did you register for this bill?
I'm apologize for not being clear at the start. I am for Marsy's law. I am here.
I know you're for Marsy's law, but how did you register for this bill?
Oh, well, in favor.
Okay, that's what I need to know. That's what I thought. But
I apologize, Senator.
No, I might have missed it, but
No, you did not. I neglected it. I apologize. Okay.
yeah, I really appreciated your testimony, and what you really helped me on is why constitutional versus statutes, and I thank you for that. And what I thought was really meaningful to that discussion from your point of view is you said there were three important reasons why constitutional versus statutes. One, it helps clarify overall, but it helps clarify your values as a state. I thought that was really an important statement, and that it gives an idea of what the victims can do, what actions they can do, which I thought was really important, and also gives insights into standing in court. I thought that was really helpful, so I thank you very much for that. And I also want to ask you, what advice would you give us? Is there something we should change or add to the bill as is? Is there anything specific you would recommend?
No, in terms of changing, what I don't vote here. I'm not one of your citizens, right? So I want that clear. My recommendation, though, is to move swiftly for victims. You were a leader in 1993. You, from what I understand and from what I've read, I pulled up everything from 2017. You worked on this. And so I think at this juncture, putting it to the people and saying, is it a fundamental value or not, makes sense. I also think continuing in the future after this is on the books to do things like the senator mentioned, which is funding other aspects of the judiciary, the criminal justice system, can only amplify all of this and make it more meaningful. I don't think they're a either or. I think it's a both and.
Well, I think specifically what you were talking about, Senator Taylor, was more resources for victim training, education, and advocacy.
Senator, absolutely, I would echo that.
Obviously, there always will be resource demands for the court, so I think specifically that kind of assistance would be valuable from what we've heard.
And Senator, I would absolutely agree with that. I would say, right, fundamentally, in the criminal justice system, there are two human beings whose lives are impacted, the accused and the victim. And they both need resources. And they both need rights. And they need rights that compel a conversation of equal value, and they deserve resources that are funded. And so I think this body can both give rights and help move forward the needle on resources.
Well, you just gave a brilliant testimony, and I really appreciate that. And I hope we can get you back to talk about trafficking, because we really came to a whipsaw on this very important issue, so maybe we can get you back to help us with that.
I would be happy to be helpful in any way I
But
can,
thank you, it was
Senator.
really delightfully brilliant.
Senator Taylor?
I too enjoyed your testimony so much so that I had to make sure that the public saw your testimony, because I thought that you did bring up some very good points. And I personally wanted to make sure that you knew of what we had on the books from 1979 to the present. And I think you said something also that, screams to me for this particular piece of legislation, that if it's not clear, it's difficult to enforce, for enforcement purposes. And so I do feel like, especially for item number 5, item number 9, and item number 12, and item number 15.
He has you on the floor.
That I have some concerns that have been articulated. But I also really appreciate Representative.
He gets like this when he's over tired.
Sorry, Representative Forlocker.
Haven't seen him on TV?
Question about with rape shields and how it exists, and I think that's one of my main concerns.
Who's this part?
As well, which is the discovery issues and refusing to interview. That kind of thing. I believe that people have the right, to question their accuser and, so on and so forth. And I am concerned with the things that I've heard that are not clear. But I'll tell you something that you, and the last thing that you said, something that you said that I think is really important, is that both of them are in the courtroom, and that there needs to be resources for them. And part of what I'm articulating is that as a state, if counties collect 100% of whatever they collect, if we take 70 and we leave 30, why do we think there's a problem with victims coming through court and not being able to adequately understand and know? Because we've made our system into a assembly line, so that people have no sense of anything other than I gotta hurry because my caseload is insane and I really don't have time to. That is our experience. And as someone who, I can't believe I'm saying this, but since 1993 I had a license to practice. It is very different in the courtroom, and so I adamantly believe that the victim witnesses, there needs to be more of them. And there should be the person that's with the DA and the person who can explain the process. Very different, because if I'm with the DA, I really don't have time. And so I think your testimony, has, been very valuable. I don't think our values are different in Wisconsin. I think our values do show that we are concerned about the process, existing. But I do believe that because we have deprived our systems for so long, that it makes it very difficult from policing all the way through. And I hope that you will come back to support legislation that I know the Senator Josh is doing, and to talk about not only, even if you don't come back, but to share, because we have some great people who talk about human trafficking in their own state, but the concept of human trafficking and doing something to say that the person, the accuser, gets like some kind of, and sexual prostitution and all that, that they get some kind of fine or something that can go, and it has to go to help, actually, people who are helping people who are being trafficked, and that actually those services are being performed by somebody who understands that process. It's kind of like what the gentleman said, that woman was helping the other women. Kind of when you've been through it, you understand it at a different place. And so any help that you can give for that work, we want to see it.
Senator, to all of you, I am happy to be of assistance or to provide information at any time. I do think you also, Senator, nailed something there, which is oftentimes the criminal justice system, and we heard it from the survivors, it's moving. It's a conveyor belt for them. It can be for an accused also, right? And it's moving very quickly. One of the things that making rights clearly enforceable in your Constitution, adding that piece, making that clear, what it does is it makes sure everyone can stop when they need to and analyze the rights. And if you get it wrong, you can do something over, right? You can't undo a trial. Nobody wants to undo a trial. Double jeopardy attaches. That's fundamental. But when you forgot to notify someone out of pure mistake, and you have a critical hearing, and the victim had a right to it, I get to say, whoa, 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 slow down. Can you do that hearing again? Because I get to have a voice at it. I get to see justice in action. That would be part of what you're getting at here. And I certainly respect all of the questions and values that have been articulated here today.
I know you're gonna catch a plane, but Andrea, you had a question.
This
Remember,
is
she has
way
a-
more important.
She has a flight she has to catch.
I will keep it very brief, Mr. Chairman. Thank you. And I am extremely excited because I know we have a lot of people on both the Senate and Assembly side that are very interested in working on human trafficking and victims' rights. And so, yes, we certainly will be in touch with your office. And I know Senator Taylor and I are working on human trafficking legislation. Representative Emerson, of course, you have been very influential on it prior to your time in the legislature. So look forward to working with you as well. Senator Darling and Senator Wongard and Representative Horlocker and everybody. So I'm very excited with the enthusiasm here. I guess one thing that I would ask, I don't know if you had much of a chance to look in depth at Chapter 950 where we have the statutory victims' rights language, but I'm curious if, because Wisconsin is one of the pioneers and we did do an update about 8 years ago based on, of course, we had the Ken Kratz situation, we had the issue with kind of restoring the teeth. Is there anything in Wisconsin that is markedly different from other states or that we should consider potentially adding that would work in concert with this constitutional amendment in the future? I know that there's certainly other victims' rights legislation that doesn't necessarily fall within Chapter 950, but I'm just curious if...
Senator, I am familiar with this, but I don't want to speak out of turn about what could be added to it at this point because I didn't study it prior to this hearing, but I'm happy to send some ideas. I will say, I do know about the amendments you did a number of years ago to stealing Steve Doreen's terms, make it less gummy of a law, have teeth. And those were huge improvements. I do recall that. I am happy to take a look at it and see what could be further done to it to continue to advance rights here. I'm happy to send some information after I just don't want to speak out of turn.
No, that would be fantastic, and I realize that's dealing, well, it is related, it is separate, obviously, from the constitutional amendment. So thank you very much for being here.
And we don't want to put you on the spot because we don't want you, Mr. Plain. So can you get that back to us by next Tuesday at 3? Just
I'll
kidding.
have my law students do it.
Yeah, that's good. I have staff too, so I like that. Thank you so much
Thank you all very
for being
much.
very informative, and I just like the way you laid it out. It was so crystal, so unlike a professor. I mean, it was just so crystal clear, you know?
I am going to take that as a compliment.
That is a
Yeah.
compliment. It was really great. I just want to tell you that. It was very, very well done.
Thank you,
Thank you.
Mr. Chair, it was just like a law professor, quick, and hope you get it. And if you don't, you better go read it.
So are you an attorney also?
I am.
Oh,
yes.
my goodness, she's an attorney on top of it, so this is good.
Yeah.
Thank you
Thank you
very
all very
much.
much.
Much appreciated.